Hello, doctors. I'm Dr. Chris Rapoff of QME Continuing Education, and welcome to this week's Case Law Update. Today I bring you a case with a twist. In the Sanchez versus the State of California, the applicant sought reconsideration of the workers' compensation judge's decision. The applicant, in this case, Mr. Sanchez, alleges that the medical QME and the work comp judge erred in finding that Mr. Sanchez did not contract valley fever while employed as a correctional officer for the state of California. This requires us to visit Labor Code 3121-10 for some guidance. Did Mr. Sanchez convince the appeals board and cause them to reverse the workers' compensation judge's decision? Well, let's take a look. Let's get started. So, according to Mr. Sanchez, he actually contends that while he was employed as a correctional officer, he did sustain an industrial injury to his respiratory system and musculoskeletal system in the form of coccidioidomycosis, commonly known as valley fever. All right, now for a microbiology refresher. Pulmonary coccidioidomycosis is an infection of the lungs caused by the fungus Coccidioides. So coccidioidomycosis is commonly called valley fever. You can get valley fever by inhaling spores from the Coccidioides fungus, and also valley fever fungi are commonly found in the soil in the desert regions of Southern California, southwestern United States, and the Central and South America. According to the medical QME and the work comp judge, they previously found that Mr. Sanchez's valley fever was not considered an industrial injury. Now, according to the appeals board, they actually rescinded this decision and returned the matter for further development of the record and for further analysis to determine if the applicability of a Labor Code section 3121-10 applies here. So the appeals board contended that this new labor code, or this labor code that existed but was not used here, creates what they consider a rebuttable presumption of industrial causation when a correction officer develops or manifests pneumonia during his or her service. The appeals board concluded that this presumption had not been considered by the parties and the work comp judge in these proceedings leading up to their decision. Mr. Sanchez again contends that the work comp judge erred in not finding the industrial injury in the form of valley fever, and the appeals board did grant reconsideration. They also at that point rescinded the work comp judge's decision and issued a new decision reflecting that the applicant sustained presumptive injury in the form of valley fever. Very interesting. Okay, let's get a little bit into the weeds here, but as it is relevant to this case, Labor Code section 3121-10 states that in the case of a peace officer of the Department of Corrections, they would have custodial or supervisory duties of the inmates or parolees in this case. The term injury is used in this division and does include pneumonia. Now, this pneumonia would develop or manifest itself during a period in which a peace officer covered under this section was in the service of the department or the unit, in case this was. Now, the compensation that is awarded for the injury includes full hospital, surgical, medical treatment, disability, indemnity, and death benefits as provided by the provisions of this division. Now, this pneumonia, so developing or manifesting itself, shall be presumed to arise out of and in the course of the employment. So there is your AOE, COE. This presumption is disputable and may be controverted by other evidence, but unless so controverted, the appeals board is bound to find in accordance with it. This presumption shall be extended to a member following termination of a service for a period of 3 calendar years or each full year of requisite service, but not to exceed 60 months in the circumstance, commencing with the last date actually worked in the specified capacity. Now, with this in mind, Mr. Sanchez's attorney entered into evidence previous cases in which valley fever had been found to constitute pneumonia. At that point, they returned the matter to the trial level to investigate whether or not they could consider the labor code in this case. So to trial, they brought the medical QME's initial report and a subsequent supplemental report as he addressed this very issue. And the QME said that he was very familiar with the case of police officers in the Department of Corrections who has custodial supervisor duties, can develop pneumonia, also heart trouble, tuberculosis, meningitis, and is presumed to rise out of and in the course of their employment, including some cases that some people were entitled to presumption of valley fever as having been identified as in pneumonia. Now, this QME was pretty steadfast in his argument, and he stated that Labor Code 3121-10, that the presumption did not apply to Mr. Sanchez's case because Mr. Sanchez lived in a hyper-endemic area, and he provided several studies issued by the CDC with prisons in the valley that it would be impossible for a QME or virtually anyone else to determine the causation at this point of valley fever in the valley in a hyperendemic area. So in other words, Mr. Sanchez could have contracted valley fever at any number of areas where he lived. With that, the QME stood by his original decision by stating that, quote, there was not enough substantial medical evidence to support within reasonable medical probability that this was a work injury. And you can understand the QME's question. He provided the goods, he provided the receipts, the how and the why he made his conclusion. Now let's take a look at what the appeals board responded with. They indicated this Labor Code section 3121-10 creates a presumption affecting the burden of proof that an injury under its scope arose out of and in the course of employment. Boom, there's your AOE-COE. Now remember though, ordinarily, the applicant seeking the workers' compensation benefits has the burden of proving industrial causation. So it's the applicant's duty to prove this. However, they state, and I quote, the effect of a presumption affecting the burden of proof is to impose upon the party against whom it operates the burden of proof as to a non-existence of the presumed fact of this labor code. And that consequently shifted the burden of proof onto the employer to show that the injury did not arise out of and during the course of the employment. So the burden of proof went from the applicant. With this section, Labor Code 3121-10, the burden of proof then switched and went to the employer. And finally, with the appeals board decision, they began their final ruling by stating that both the QME and the workers' compensation judge found that the labor code in question, the presumption was established, but they concluded that it was rebutted. Now the appeals board responded by telling us that the QME never states, let alone provides substantial medical evidence that Mr. Sanchez's valley fever probably not contracted at work. So if you see that, it's the negative is what they're talking about. And they concluded that the case of the injury, quote, is impossible to determine. But this in and of itself, the board stated, determined that did not meet the burden of overcoming the statutory presumption of the labor code in question. Therefore, the reconsideration ruling was granted. They rescinded the workers' compensation decision, issued a new decision reflecting Mr. Sanchez's sustained presumptive industrial injury in the form of valley fever. Once again, doctors, I hope you enjoyed this presentation today. This case is another illustration that our commitment to learning as a QME is really an ongoing process. It takes cases like these also to remind us, as surprising as it may seem, that there's always more to learn. Well, I'm Dr. Chris Rapoff, and I wanted to thank you again for taking the time to join me in the presentation. I hope you enjoyed it, and I look forward to sharing another interesting case with you again soon. Until then, take care.